Thank you very much Las Ken Corla. I'd hoped to be able to share my time with Deputy O'Riordan, half and half, but he's not here, so I'll lanarige, as they say, and
we'll keep going. You're all right.
We'll see how we get on.
He's probably out in North Central.
I'm sure he's representing them quite well.
Here we go.
Thank you very much, Las Ken Corla.
Get the whole thing right now.
And say that the legal profession, certainly in my view, is one which doesn't deserve sympathy, but it's certainly one which requires understanding. My own background, I entered Blackhall Place in 2009 and hopefully will graduate at some stage this year, delayed a little bit by my election to this House. So I have a small but insightful view into the legal profession, although not as accumulative as the ministers. I think that point needs to be highlighted in this debate today, is that of the people who entered into the Blackhall Place with me in 2009, the vast majority of them will be qualifying in April of this year or in January of this year and will be graduating onto the dole. The legal profession has taken a huge hit over the last number of years, and people who have spent years after achieving their undergraduate degree, studying for FE1 examinations, going through Blackhall Place, putting in another 3 to 4 years of effort to gain a qualification, will be going into, will be looking at a very difficult legal and professional landscape. And I think that itself, that preponderance of unemployed legal professionals, will probably do more to increase competition in the area of the legal profession than this bill will do it on its own. Just a number of issues that have been raised over the months since the Legal Services Bill was raised. I think that, first of all, I think the tone of the debate from the start has been probably a little bit unfair and has not been very conducive to a constructive debate in many instances. Some of the criticisms of the independence of the proposed regulatory authority, whilst maybe based in ground, but comparing it to some countries in which totalitarian regimes exist, I think certainly wasn't very constructive. But I do accept that the Minister has pointed out that he's open to amendments on the issue, and that he is certainly open to looking at it correctly. I think what the problem is, and so much in public life and in the public sphere, is to do with perception. And if perception if it's not seen to be right, public confidence in that can be undermined. So I will take the Minister's word that he will look at that issue and that he's open to amendments, and I thank him for that, and I expect that a satisfactory conclusion can be reached on the matter. On the issue of the complaints, from my time in a solicitor's office, I know very well that a referral to the Law Society was something that was treated extremely seriously. It wasn't seen as an easy option that you went before the network, your friends would let you off. It was something that you certainly did not want to happen. But again, from a public representative point of view, I've had people come to my constituency offices telling me that they think that the Law Society is absolutely incapable of being a fair adjudication of people's disputes against solicitors, and that they would be loath to report a solicitor to his own profession for guidance. Again, you're back to the issue of perception. And I think the Law Society itself has come out in the last number of weeks and acknowledged that disparity, acknowledged that public perception, and has changed its view with regard to regulation, that it is now of the opinion that an independent regulatory authority should be the body to deal with complaints. And I welcome that, because I think it will only help to enhance the reputation of the solicitor's profession and to enhance public confidence in the profession as a whole. The issue of costs, I noticed that it's one that has received widespread welcome across all the professions and those commentating on the bill. And the new Office of Legal Cost Adjudication is to be set up, which will provide a new level of transparency, supervision and scrutiny, which I believe, again, is vital. If people complain to you about solicitors or barristers, it's invariably almost completely about costs. The lack of understanding in the way in which costs are made, the hourly rates that are charged, the issues with Section 68 letters, the work that is done behind the scenes that the customer does not know about, but all the work that is done in that office, there's just a complete distrust between the petitioner and, in some instances, and the client. And I think this new body, which will be independent and will be adjudicating costs, is a very welcome step in just creating a formal structure that can be seen that both sides are getting a fair hearing, and will certainly help to enhance the reputation, I think, of the legal profession. On the multidisciplinary practices, I think there's been some area of overreaction to this. It's something that I think you really have to see it in operation to see how it will affect the legal system. I take some of the points about, I mean, Deputy McGrath mentioned about an auctioneer, an engineer and a solicitor working together. I think it's a highly unlikely probability that that would be the kind of example you would see. But I mean, we will have to see it in operation. A solicitor and barrister working together in a multidisciplinary practice, again, from a step back, doesn't seem to be an issue. But I note over the years that there has been a gradual erosion of the distinction between barrister and solicitor. I know, for instance, that many solicitors are entitled to audiences in front of any court, and in fact the Minister is one of the examples of solicitors who have often exercised that right. So there really is no necessity now in law for the existence of two separate professions, and that by working together, I think you could see a blending of the roles if a solicitor and a barrister are working together, and that's not necessarily a bad thing at all. I noticed that there's a section 30 of the bill that calls for a number of reports to be prepared by the new regulatory authority, and one of them is on that issue of the unification of the barristers and the solicitors' profession. And I think that the Minister will certainly get an interesting reaction from the two professions when that report comes out, and we'll really see a fuss if that proposes a merger of the two professions. One that I also welcome, however, is the report into the education and training of legal practitioners. I could not question or fault the training that I believe I received in Blackall Place. However, it was the only option I had. There was no other alternative to become a solicitor. So that was it. The one authority, one option, and in my view, it was a very expensive privilege to have to do. In fact, I'm still paying off my education costs from Blackall Place. So it'll be interesting to see if there's a way of making that more affordable, more open, and more easier for people to get through. Just before I finish, and Les Kencourt, how much time is there remaining?
There's 12 minutes in the total slot.
There's 12 minutes. Sorry.
Deputy Reardon has the right.
I'd hope to give Deputy Reardon 10 minutes.
There's 2 minutes left.
2 minutes left, thank you. One of the issues that, as a public representative, frustrates people the most is not necessarily those who practice the law, but the law itself and the method in which it's administered. And the very fact that trying to vindicate or trying to exercise remedies granted by the Dáil or legal opportunities for redress can take so long. The delays can be enormous. You can be years waiting for a decision. If you're looking for settlement in terms of money, you can get your decision years later, then have an entirely new legal battle to get the enforced judgment. And for many people, they can't understand that long, drawn-out process. And in many ways, I think that does more to hamper people's rights, to hamper people's confidence in the legal system itself than any practitioner that's involved in it. And I think that those issues of enforcement, of costs, of delay, in merely vindicating the rights that have been granted by the Oireachtas is something that could take another days, that could be looked at again. I think that the court service is still based very much on paper, very much on old methods of doing things, filing, stamping, and that so much of that could be done electronically. As someone who's not that old, entering into a solicitor's office, I was certainly of the view that there was so much that could be done quicker, more efficiently, online, electronically, and that in itself, that process of modernisation of the administration of the court system and the administration of justice, I think would also go a long way towards reducing costs. So they're my points I wanted to make, Les Kencourt. I thank the Minister for his attention and for being in the House for the second stage of the bill. And I look forward to seeing the bill go through committee stage and some amendments coming forward.
Thank you, Deputy.